Well, I want to welcome everybody to our webinar, our legal webinar, hosted by Mirza Healthcare Law, the BCMA, and the Dade County Medical Association, and obviously myself. Each month, we have one topic that we cover intense, 1 hour of intense learning for physicians and other healthcare executives. And today, as our presenter is, and usually is, Ben Mirza, who is with the law firm of Mirza Healthcare Law. And I'm going to turn it over to Ben and his presentation. Ben, it's all yours.
Thank you. Thank you, Charles, for hosting this. Thank you for being a voice for those unheard in this community, frankly. I think the South Florida Hospital News is definitely a forum that helps people come together. So thank you for doing that. And thank you to the BCMA as well for being a partial host to this as well. I'm going to kick off this presentation. So I'm going to let me know if you guys can see this. And what I'm going to do is, hold on. Let me do stop share. Let me do share. Okay. There we go. I'm going to bring this over to here so I can actually look at it. Can you guys still see it?
Yes.
You can still see the presentation, right?
Yes.
Yes.
Okay, fantastic. Slideshow from the beginning. All right, here we go. So today we're going to be talking about how to navigate, privileging, peer review, hospital medical staff bylaws, and what happens through the hearing process that a lot of you hospitalists.
Ben, I don't see it in the presentation mode. You're still in like.
Oh, really? Okay.
Hit from the beginning. Go to where start from the beginning.
Yeah, let me go stop. And then let me do
share. Yeah.
All right. It's just I'm trying to get it all onto this one screen.
There you go. You got it. Okay, you got it. Okay. Everyone can see.
All right. So basically, today we're going to be talking about this process of what physicians go through as they go through privileging and peer review. Just by way of background, I'll be really brief. I've been an attorney since 2001. I've got several degrees. I like to collect diplomas like Dr. Donaway. I do have several of these, and some diplomas are not even on here. So, but in the past, I've worked for like large hospitals. I've represented smaller groups. I've represented individual physicians. My practice is mostly physician-centric. I do a lot of mergers and acquisitions, and I also take care of the appellate process as it relates to the MEC when it comes to physicians and protecting their rights. So just as a matter of disclosure, this presentation is only intended for educational purposes. It's not intended to be legal advice. The seminar is open, live, and being recorded for use on a public online resource. Today's presentation is going to be about 50 minutes altogether, and I think we're in it for a couple of minutes already. First, I'm going to set up a case scenario. Then we're going to talk case scenario so you can kind of get everybody aligned into the same way of thinking, and then you'll figure out how that case scenario applies to you or may not apply to you, and you can sort that out. But it's a good practical scenario to kind of have in the back of our mind as we go through the whole presentation. Number two, we're going to go through the actual governing documents that regulate this whole process. We're going to talk about how credentialing and privileging is done. We're going to talk about peer reviews and the professional review activity, and then we're going to talk about actually disciplinary actions, appeal rights, and the eventual relief that civil circuit courts can offer. And in the end, we'll probably have about 5 minutes left for questions. So if you do have questions along the way, please do raise your questions as we proceed. Especially if it's a burning question, you're not the only one probably thinking. So let's, I always start off every single seminar with some sort of a market force, what's pushing people into this area. And, right now, there's actually several things that are going on. Number one, there's actually a shifting in payment structures, right? So as there's a shift in payment structures, people are either gaining or losing money depending on which way the payments are shifting. And and then that really creates a turf war. And inside hospitals, these privileges are, and I'm not kidding you, it's a turf war. And it's a turf war because there's private groups, there's individuals, and then there's the hospitals themselves. And everybody's looking to see what portion of the pie will they get. And so that's the number one market force in my mind. Number two, there's also liability lawsuits that are out there. So this process is important to that. Like in COVID-19, there was emergency credentialing that took place. So this process also applied to that. And there's also changes in certificate of need. CON stands for certificate of need requirements. And that also affects credentialing and privileging process. So these are the market forces in place. Some of them are statute, but I think overall, the overarching one is the one involving money. So here's the case scenario, right? So all hospitals, so I'm going to set this up for you. Most hospitals, no, not most hospitals, all hospitals have pretty much a notes requirement. The number of days that a physician can take to get their notes in. Some hospitals have it within 24 hours. Some I've seen 48 hours. Some I've seen 5 days. Some I've seen even as long as 7 days. So why is that so important, right? And it's basically a rule set up. So in this scenario, there's a rule set up by the hospital, which seems to be fairly trivial, fairly easy to comply with. But what's the reason behind it? Well, oftentimes the reason is if you don't get your notes in, as the patient travels through the whole conveyor belt of the hospital, how does the next department know what the last department did? And so, if you don't get your notes in on time, or if they're not fully complete, it's a problem. From a physician's perspective, what they're thinking is, well, I'm working on this high volume of patients. There's a lot of financial pressures on the hospitals, and they're just trying to make me submit notes quicker so they can bill quicker. And all of that may also be true. So you've got really competing reasons or causes on both sides. But let's say that the physician keeps violating the number of days that it takes to submit the notes. What's going to happen then? Right? So, the hospital is going to basically say, these are simple rules, why can't you follow them? The physician is going to say all modifications, if they modify their notes, they'll be saying, I'm doing what's in the best interest of the patients, and what I did, I thought was appropriate action. Well, ultimately, it'll rise to the level of where there may be an investigation. There may be a peer review done on the individual. It might be because there is some sort of data points that stand out, or there might be some sort of a turf war that's going on. But what happens is, and I'm going to talk about turf war quite a bit in this process, only because I've seen that happen multiple times. So if there's a turf war going on, what the hospitals will sometimes do is they'll isolate the one individual, but not everybody else. So like everybody else who they like can submit their notes pretty much as they need to. But the one person that they don't like, they may be requiring them to be absolutely tight by that particular deadline, and that's a problem. That's an unfairness or to the individual, because they're not enforcing their rules the right way. So what'll happen is they'll go through a whole hospital process, which is this part right here, and and we'll talk about this in more detail coming up. And then once that happens, the next alternative that is left for the physician is to go into an outside court where you're essentially appealing the decision of the hospital. So let's go back to now, first things first, let's talk a little bit about the textbook sort of issues. Medical staff bylaws, what are they? What do they do? They essentially govern and organize the medical practitioners in a facility. They determine how clinical privileges to practice are obtained, and they set the requirements for continued membership, which is really to ensure quality patient care, care standards and procedures are being adhered to. So the medical staff bylaws really govern the medical staff members as well as the allied health professionals. Allied health professionals would be those individuals that are assisting in the provision of in providing health, like the PAs and the nurses and so forth, right? So, by the way, just keep in mind that Medicare's conditions of participation require that there be a medical staff bylaws and there be a governing body and be organized in order to participate in Medicare if you're a hospital. So obviously the hospitals are going to do this. Now, next, to actually differentiate, there are not only hospital medical staff bylaws, but then there's also rules and regulations that apply to the medical staff. So the first half of the screen, this top part here, is really intended to be a collaborative effort between the medical staff and the hospital board. And the medical staff is essentially charged with leading that cause and making sure that the medical staff bylaws are appropriate, that the rules and regulations are also appropriate, and that they're also being followed. Now, down below, as you'll see, there's also what's called hospital bylaws. Now, they apply to everybody, not just the medical staff, but to the entire staff, all actors in the hospital, as you can see. Now, then the hospitals will also set up policies and procedures, which are also set forth by the hospital board, and those are, and they regulate the operations of all professions affiliated with the hospitals. Now, this second part down here is issued by unilateral action of the board. So meaning that the in-house staff will come up with what needs to be set out in terms of hospital bylaws as well as policies and procedures, and the board just has to approve it. And that's how it's generally done. When I've been inside Broward Health, when I've been inside other hospital organizations, that's how these governing documents come to life. Any questions so far? Okay. So no matter what you do in this area, you got to start off with the medical staff bylaws and the rules and regulations that apply, especially when you're a physician. Now, this is the code for Medicare conditions of participation that require that there be a governing body, and it relates to the medical staff. So if anybody's interested, this is the code to look up in the federal regulations. Now, also keep in mind the Joint Commission is behind all this. This isn't just being done by the federal statute itself or the hospital itself. The Joint Commission also comes into these hospitals because they're the accreditation body, and they want to make sure that the hospitals meet the minimum standard for what CMS is requiring or Medicare is requiring. So they are looking for basically a process that's established by the hospital that affords due rights to the physicians, and really what they care about is are the patients getting quality care? That's their biggest concern. So the Joint Commission stresses the need for collaboration also between the governing body and the medical staff in enacting the bylaws. Not one body may actually do this unilaterally. So the same collaboration is required when seeking amendments to the medical staff bylaws. So the Joint Commission also has a hand in this, not just CMS. There's other rules and regulations that apply, like the HCQIA. I'm sure you guys are familiar with that, but which gives immunity to those that are administering the peer review process. However, the immunity does not exist under state and federal fair employment laws, but it does exist under HCQIA. Now, keep in mind the NPDB, the National Practitioner Data Bank, also applies to this in a big sort of way, and we're going to touch on that a little bit later on. But the NPDB, If you're a physician, you don't know much about it, I suggest that you go and read their manual on it. If you'd like a copy, email me and I'll email it to you. I have it. I've downloaded it. It's in my library and I refer to it pretty often myself. So, oops, sorry, I already went past that slide. This is the one slide that I was just talking about, the National Practitioner Data Bank. So now let's talk about the Florida law for medical staff. The medical staff bylaws are really considered a contractual agreement between the medical staff and the hospital. So remember, medical staff bylaws are not a statutory animal. They're really, once they're created, they turn into a contract, and it's a binding contract between the medical staff and the hospital. And it's not done unilaterally. It's done in collaboration, and that the medical staff is tasked with ensuring that the expected quality of care is administered in the hospital. And due process rights for medical staff must be enumerated in those bylaws. If they're not, those bylaws lack a lot. And that's what I often review them for, is to look at how the due process rights are laid out. Now, there's different types of medical staff memberships, and this may be a review for some of you guys. Some tidbits will be new to some of you guys, but if you've been involved, like Robert Fliegelman, I think you're probably pretty familiar with a lot of this stuff. So there's several different types of status that the medical staff can have. They can be on active status, they can be on provisional status, they could be even considered a consultant to the medical staff. There could be honorary staff, meaning like those who've retired. They don't have any right to vote, but they are still involved. There's also disaster privileges provisions that are allowed, and some physicians are allowed disaster privileges. Then there's obviously telemedicine privileges too, and that side of it is growing more and more. So so remember, general surgery, neuro, ortho within a hospital are comprised of staff of various categories, and that each one is a category in and of itself, and it's a specialty, right? So when we go through the privileging process, we'll talk about that a little bit more. Now, the Medical Executive Committee adheres to the medical staff bylaws, and the president of the MEC must be a physician. That's actually a requirement. I've read it somewhere. I didn't get to actually cite that on this particular presentation, but I read it, and yeah, it only makes sense that the president of the MEC must be a physician. There are other officers on the MEC, but they must be enumerated in the bylaws. Keep in mind that there are committees and subcommittees. These subcommittees can be such as the Qualifications Committee, the Bylaws Committee, the Peer Reviews Committee, Health and Wellness Committee. There could be a ton of different committees, and there's no stopping them. But it obviously depends on the size of the hospital. If it's a big hospital or a small hospital, the smaller the hospital, the more consolidated this process gets into the hands of a few. The larger it is, the more people get involved. So these are, so far what we've covered is really the governance of medical staff. And next, let's talk a little bit about the processes. So credentialing and privileges, right? So credentialing, really, you have to think about, credentialing means verifying and assessing the qualifications of a physician or a professional. Privileging is the identification of the services that the physician will be performing. So the credentialing is just the first part. Privileging is the granting of those rights. So remember, CMS requires all healthcare providers and practitioners in a hospital to be credentialed and privileged based on the scope of their state laws, licensing, and medical staff categories. Hold on. Whoops. Did I let everybody in? Okay. So credentialing and privileges. Here are the basic 5 steps that are involved in it. There is typically a credentialing application that's filled out by the physician, and in that there's authorization forms, there's releases of liability that they'll sign off on, and acknowledgement of the medical staff bylaws. So that's the actual application itself. Then what will happen is it gets turned over to a staff member at the hospital, and they will go through the verification of the licenses, the education, the training, reviewing the individual on the NPDB, the National Practitioner Data Bank, and they will also look into the professional or peer references that the physician has provided. This is still the just the application part of the process. And then what will happen is once that verification is done, it goes on to the department chair. Then the department chair actually evaluates it to figure out whether the application is complete or not. Now, remember, up to step number 3, your application is still not deemed to have been turned in, okay? So what will happen is that the better department chairs, if they know that they're accepting somebody, they'll forward the application onto step 4. And the better department chairs also know who not to accept or who the medical staff committee will not accept, right? So what they'll do is at this juncture, they'll call up that physician and basically say, hey, look, you don't qualify for XYZ reason, and I don't think your application is ready to proceed. So I suggest to you that you abandon your application at this stage, which most physicians will go, oh yeah, okay, that makes sense, but sometimes they don't. Now, let's say that the application goes on from step 3 to step 4. What happens there is if the application gets passed, not a problem, it goes on to the Board of Governors, it's done. But here's the pitfall in step number 4. If it gets rejected because the medical staff committee basically says, hey, this person should not be on our staff, and they come up with a sufficient basis for why someone should not be, which has got to be something really appropriate to the situation, that's deemed a denial, and that denial is reportable to the NPDB. So a lot of people don't know that, but that's something to keep in mind. A denial of privileges, once the application gets to the step number 4, is deemed a reportable event. So this is the basic portion about how you go about getting privileges, and that's kind of I broke it up into like a 5-step process. All right. So what are they doing in this credentialing process, right? So CMS basically requires that the bylaws articulate the review criteria for evaluating applicants. And typically what's included is the character of the individual, the competence of the individual, their training, their experience, and their judgment. Now, those are very broad sort of categories. Certain departments may actually tack on additional requirements, but remember, they have to disclose them ahead of time what those requirements are, and they need to be just, fair, and reasonable. Keep in mind that the reappointment of credentialing and privileges must be done every 24 months. So it's like a rotational cycle. Every 24 months, this process is followed. All of the records are brought up to date. Everybody goes through that same process all over again. It's probably on the anniversary date of when the physician got into the hospital. Now, it's kind of obvious, but keep in mind, hospitals cannot grant privileges they do not have. So, like, I don't know, let's say that there's lung transplant. Somebody's seeking to get lung transplant privileges, and if the hospital doesn't have that, obviously they can't grant. So, and also telemedicine requires credentialing too. We talked about this bottom part here. Rejection of an applicant is a reportable condition to the NPDB, and I can't stress that to you enough. Now, let's talk a little bit about immunity. So the hospital committees actually have a level of immunity that they're granted, provided that the committees are acting in furtherance of healthcare quality. So meaning that it's got to be an altruistic cause, that they're doing it for the right reasons, and that they're doing it through a reasonably fair process, that they're looking at the facts, that they're allowing for hearing, and that the final actions of that committee are warranted under the circumstances. So As long as those four things are there, no one on the actual review committee can be sued individually. Now, can the hospital be sued? Yes, but the individual cannot be. So if these four things are followed, the review committee has immunity. But if any one of these four things is missing, they lose their immunity. So it's really important. If you're on the MEC, make sure everybody abides by this. It's really important that everything that you do is in furtherance of quality, that that there's a reasonable effort expended to gain all the facts of the matter, and that there's a fair review process. Now, there is no immunity if the hospital failed to exercise due diligence in credentialing or monitoring. So there's no immunity if there's if there's a failure to exercise due diligence. So just keep that in mind. If the applicant is denied, it is probably a reportable event anyway. So we've talked about that. Let's go on to the next item, which is peer reviews, right? So what's the purpose of a peer review? It's really for purposes of performance improvement, quality assessment, and quality assurance. Right now, we are about halfway through our presentation, just so you know. So net, it's a physician's a physician is reviewed by other physician, right? So if there happens to be a fallout, meaning something negative is going on, there are several things that can be done before a formal review, a formal process is taken on. Part of that could be collegial intervention. So a lot of the more seasoned physicians know, like, collegial intervention, listen to your colleagues, keep an eye as to what you're doing right, what you're doing wrong, kind of bring the other physicians along. So collegial intervention is definitely one of those things. Education suggestions is another thing that could be handed out as a request. You could even be asked to have a mentor if something that the physician is doing is not proper. You could even send them to counseling. Let's say that there's some sort of a drug abuse, anger management issues, behavioral issues. You could send them to like some sort of counseling. You could send them to some sort of therapy or workshops. And there can even be a second opinion requirement. So the second opinion requirement, you have to be a little bit more careful of. If the peer review committee is asking the physician to get a second opinion as a requirement prior to doing a procedure, that is really that's actually a reprimand. Versus if they are asking, hey, why don't you get somebody to go in and evaluate how you completed your procedure after the procedure is done, that's very different. That's treated in two different ways. So if there is intervention before the physician is doing their procedure, that's actually a restriction upon their rights. And there needs to be a basis for it. If there's a restriction upon their rights, also remember, it becomes a reportable issue to the NPDB again. But if it's a review being done after they've completed their procedure, it's different. Same thing with actually proctoring, right? If you are required to have proctoring done and it goes on for more than 30 days, well, now that's another NPDB reportable issue. Anger management, sexual harassment, behavioral boundaries courses are a part of the course. And so, a lot of physicians get asked on the sidelines, hey, why don't you do this? Just to make sure that everybody's flying in alignment inside the hospital. But sometimes it doesn't quite go that way. A lot of these peer reviews complaints can be resolved with conversations. So I ask my peer review committees, the medical executive committees, to actually embrace these sort of steps before they take harsher actions. Whenever I've been inside hospital systems, I've always kind of talked about, hey, let's hold hands and get this physician through this point so that everybody is flying in alignment. But that doesn't always happen. Keep in mind, because there's a turf war going on, this can take all kinds of forms. So let's go on to the next part. So what can happen? An investigation can be started against a practitioner. So if a practitioner does not listen to those that helpful, those helpful suggestions we just talked about, and they remain recalcitrant, then there may be an investigation that's invoked. And so, number one, there has to be an activity or an occurrence, right, that took place, and either through a routine review or a specific reporting of an event. And the MEC initiates the inquiry or the investigation. So that's how investigations start. Number one, there has to be some level of activity. There has to be a routine review or a specific report that's been made. And then the MEC starts the whole investigation process. Now, what I'm about to tell you here is caution. Physician must not leave during a pending investigation. So repeat after me, you guys. No physician should ever leave a hospital while a investigation is pending. And the reason why I say that is because if they leave during a pending investigation, it is reported to the NPDB. And when it's reported to the NPDB, you might as well have taken your license and just put a big X on it, because now you become marked for life, and people look at you 5 different ways before they will retain you in the next hospital. Now, it's not to say you're gonna not be able to work, but what I'm saying is your ability to work has been hindered significantly. So, and the easiest example that I can give you is, if you actually apply for privileges in another hospital after you have first quit at the first hospital while under investigation, what the new hospital will think is you committed some sort of an egregious thing on the operating table. I mean, they're going to think the worst of the worst, even though it may be such an innocuous thing. And I've seen that as well happen, where something small starts an investigation and the physician quits right in the middle of it. Just don't ever do that. Please don't ever do that. If you ever get stuck in that sort of a path, I think it's time for you to call up your attorney, your closest friends that understand this process, and talk it through. But I've had instances where physicians have quit right under investigation, and they have literally had to leave from Florida and go into other states, into rural areas, to go and find employment again. It's not easy. So this word of caution is really, really important. All right, so how does the investigation review process work? So first of all, the practitioner may be invited to get interviewed by the investigation committee or an individual from the investigation committee. The investigation can be done either by a committee or an ad hoc set of individuals. So there is no specific recommendation unless no specific recommendation is usually made unless requested by the MEC. So what this investigation committee will do is they will formulate all the facts and take it to the MEC and present it to them. They don't come up with any sort of a recommendation unless the MEC requests them to. Now, keep in mind, competitors may serve on the investigation committee, although it's a bad idea. It's a bad idea that competitors serve on these investigations, but it does happen from time to time, especially when it is a rare sort of a profession that they're looking into, or a rare sort of an incident that, that there's no common, people don't have common knowledge about. So let's say you get some sort of a very high-end, unique sort of a specialist, a competitor may be in that. But remember that the competitor must act in a fundamentally fair way. That there cannot be something created out of nothing, right? So competitors are allowed, but they're highly discouraged. Now, the next step is the hearing panel. A competitor must not be on a hearing panel. So this is the part where a competitor just cannot even be on a hearing panel when a physician is being reviewed. So just make sure that you take care of these conflicts of interest, whether you're on the MEC side or whether you are the physician being reviewed. Just know that competitors should not be involved. Also, if you're on the MEC, any questions? Okay. If you're on the MEC, double check and provide look at your DNO insurance coverage at the hospital. Make sure that you're covered under your directors and officers insurance coverage, because in case if you do get sued, you have the ability to go and get legal counsel hired for you specifically, and the insurance company pays for it. Now, let's talk about the investigation process. So what will happen is the investigating committee will present the facts and the analysis to the MEC, but it makes no recommendations unless asked, right? So that's like step number one. That's what happens in the first step. Then the MEC reviews and they make the recommendation. They're usually one of three recommendations. Number one, take no action because there was nothing found. Number two, there's a letter or a reprimand, but there's no hearing needed because it's not really a restriction upon their rights to practice. But the physician is just being told, hey, by the way, you didn't get your notes in on time. Please, adhere to that policy. That's one thing. But now, for example, let's say that the person didn't get their notes in on time and it caused some sort of harm to patients. Well, you know what? The physician may be up for a suspension or a reduction or a restriction of rights. So these are the three possible things that can happen. The Medical Staff Executive Committee is the one that actually makes these recommendations based on the fact finding that occurs. Whatever the MEC's recommendation is, it goes to the Board of Governors, and the Board of Governors is the one that ratifies the MEC's actions, especially when it affects privileges. So like if it's A or B, meaning like there's no action taken or there's some sort of a reprimand letter, but there's no impact on their restriction, then it doesn't go to the Board of Governors. It's just taken care of. A and B is just taken care of by the MEC. But if there's a suspension, reduction of rights, restriction, or revocation, that has to go to the Board of Governors in order for it to get ratified. Okay? Let's talk a little bit about suspensions while we're on the suspensions part. Remember, there's something called an immediate suspension. An immediate suspension is the same as a precautionary suspension. When is an immediate suspension appropriate? It's when there's imminent danger to the health of any individual that's coming into the hospital by that particular physician. So like, for example, if the physician happens to be an alcoholic and they happen to be taking some sort of drugs, or they happen to be under the influence of something, that's obviously immediate danger to a incoming patient. However, there's other scenarios that may arise, and the hospital may not be sure exactly what's creating that sort of a scenario. So they may precautionarily suspend that physician. As long as the suspension does not go past 30 days, there's really no significant impact that has been imposed onto the physician. However, what will happen there is, if they've been suspended for let's say 29 days, if there's ever a question, have you ever been suspended or reprimanded? You may not necessarily have been reprimanded, but you've been investigated and you've been suspended for a temporary amount of time. You always have to answer yes to that, right? Because that issue comes up. Usually inside contracts. I see these clauses inside contracts. So if you're ever having to actually answer that sort of a question, you may want to consult with your attorney. Make sure that the question that you're looking for matches or doesn't match with your situation. And you can actually answer that question truthfully. Now, the practitioner may seek an injunction to minimize the impact on income or the blemish to their license. So like, for example, if someone gets suspended for 29 days, they might be like, look, there's no reason why you're suspending me, and I have a reason to ask you for a speedy resolution to what's going on. So the MEC definitely has to actually step into high gear and start to work towards resolving it, unless if there's a specific sort of a complicated scenario that they have to slow down the process, then that would be with reasonable cause that the process is slowed down. But otherwise, the practitioner may seek an injunction to speedily move the committee through the process. Remember, disciplinary action should be taken in progressive steps. All right, so now let's go back to our scenario again, right? Here was a scenario that we talked about where the individual, where the hospital had rules for getting your notes in on time, whether it's 2 days or 7 days. It varies from department to department and from hospital to hospital. But nonetheless, that sort of a rule is there. So far, what we've talked about is part one down here, where you see part one, the MEC action. The investigation committee does the investigation committee presents the facts. The MEC then sends a letter with specific reasoning to the physician, and then the physician's due process rights kick in. So let's talk about that, because that's our next set of steps coming up. We talked about these things that you could do, collegial intervention. This is before going into the MEC action mode. Just make sure that these have been checked off, taken care of. If there was a way to actually resolve the issue through these 5 things, please try to make sure that happens. I think it's important for physicians to be kind to other physicians, because we're all they're all under the same in this brotherhood, sisterhood of professionalism. But let's say that that a disciplinary hearing has not been summoned. There's some sort of a note that comes out that basically says, hey, we're going to actually put you through a whole disciplinary hearing process, right? And which could impact your privileges. So what will happen here is, before the MEC can take any action, number one, they have to issue what's called a notice of reasons. The notice of reasons must state with specificity the manner in which the physician failed to meet requirements. And, some things that may look like they're not specific, it may look very specific to the MEC that they're being specific. So when you get this sort of a note, you've got to really have it reviewed by another person to make sure that the notice that you received was reasonable and it was specific. Okay, and within that note, it'll say, would you like to have a hearing on this issue? So it's up to the physician to trigger the hearing rights. And typically what they'll say is, if you'd like to trigger your hearing rights, we will have a hearing for you within 30 days. And then a date of hearing can be set. But sometimes they need more, a lot of times actually, both sides need more time to prepare for the hearing. So there will be a discovery process that happens. Discovery meaning, in terms of law, that the physician will have the right to request information. There will be a document exchange. There will be a witness's disclosure that occurs. So you have the right to go and ask for the patient files, the notes in the system, the statistics that are being applied to the particular situation. So those are all considered discovery of facts, right? So the physician also has a right. The physician that the action is being taken against has the right to ask for these documents and the evidence that's going to be used against them. Now, what will also happen is there will be a hearing officer appointed to this process. And what that hearing process does is that they manage the hearing panel members, okay? So they help manage the discovery process, they help manage the hearing panel. Now, in the hearing panel, the hearing panel is the one that determines the reasonableness of the evidence, and they're the ones who come up with the disciplinary action. So the hearing panel ends up becoming very important. Now remember, nobody with a conflict of interest can be on the hearing panel. If there is, that's actually grounds for recusing them or to negate the whole hearing process. So now remember, the hospital goes through this process regularly, whereas a physician may go through it once in their lifetime. So the hospital is very adept at this. The physician is not. adept at this, and it's a costly process. So let's say that, going back to this, let's say that the hearing panel makes an adverse decision against the physician. Well, what happens next? Because don't be surprised, this being a hospital-sided process, the hearing panel comes up with an adverse decision against the physician. When that happens, well, the physician has a right to issue a notice of appeal and filing a lawsuit. Now, that typically has to be done within 30 days of the adverse finding from the hearing panel. So there's a limitation on that. The bylaws will say how much time you have, and you've got to act on it. So the filing of the lawsuit has to happen within 30 days, right? So you've got to now step into action. You got to file a notice of appeal. You got to get a attorney lined up to file that lawsuit in the courthouse. Now, there have been physicians that have been known to do it on their own. Again, it's a highly technical process. They can do it. Courts often will give individuals a lot of leeway to represent themselves. But this being, keep in mind that the hospital usually goes after the individual with a cadre of attorneys. It's not just the hospital individuals showing up themselves or the hospital officers. It's several attorneys that are on the other side. So when you look at this, you better bring your own money, guns, and lawyers, right? So you got to get ready for the fight. Again, through the court process, you have the ability to go through the discovery process. You have the right to take depositions. You have the right to ask for documents. You have the right to ask for witness disclosures. And this is all done in the form in front of a court. So there are ways to really get more information out of this process than I think even the first in-house process that they did, right? So like the first process being where there was a formal hearing panel inside the hospital. In front of the courts, you'll probably have more rights as a physician. And the playing field gets a little bit more leveled, but it's an expensive leveling, okay? So in most courts will require that a mediation take place before any sort of a trial is ever had. And then what will happen is that a case will generally resolve either through a form of summary judgment or a trial or by settlement. Most cases, 90% plus, will end in a settlement. Very few will go to trial, or there's some sort of a summary judgment. If you need to understand what a summary judgment exactly means, call me up or just look it up and Google it or GPT chat it, and that'll help you out. But I'm happy to answer those sorts of questions if they're burning in your head. So anyway, going back to this scenario. So let's talk about what this process means. We talked about both parts, dispute part 1, then we talked about dispute part 2. Dispute part 1 is a fairly expensive process. My guesstimate, and I'm only guessing at this, it's anywhere from $25,000 to $75,000 of legal fees. Okay, so if you're going to get into this fight, make sure you bone up for it. If you take it through the court process, this is anywhere from $30,000 to $100,000. That's not including what I just said in part 1. That's usually an add-on to that. So the cost of litigation is expensive. This justice is for everyone, but really it's intended for the rich. So keep in mind, I do represent physicians that make a ton of money, and they don't mind going full court press in fighting off a hospital system. They'll put up the fight, and they'll pull everybody into it. And there are those physicians that'll do that. And then there's physicians that will go out and even borrow money to go do this because they are just, they feel like their rights have been trampled on. So I think if somebody is on the MEC, if somebody is responsible for overseeing this sort of a process, it would behoove them not to really piss people off and really try to be fair, professional, and do the right thing by the profession. So with that said, we have just a little bit of time left for questions. Any questions at this stage? I know I flew through a lot of material, but what I'm going to do is I'm going to either Charles or I will email you this presentation in the next day or so, and you'll have it so you can refer to it. But anyway,
We'll also email you a link to the video if you want to rewatch part of it or all of it. So, any questions?
I have a question, somewhat related, somewhat unrelated. If the hospital tries to change the bylaws unilaterally and you oppose that through MEC, and they won't even let you record the meetings of MEC, is that legal?
It's kind of odd that they wouldn't let, I mean, recording of it. I've seen it done through actually court reporters. They're under no formal obligation to record the actual MEC meetings.
But
generally, that's
right,
how
but
it
can
is.
the MEC record their own meetings?
Can the MEC record their own meetings? Yeah, if they want to, they could.
And the hospital is refusing to let the MEC do that. How do you settle that?
Well, before we
that's
get into that, I'm going to shut off the recording because somebody's.
Yeah, let's
pushing it.
shut off the recording.
So anyway, I'm going to shut off the recording and
Yeah,
then,
let's have.
some other questions.
Yeah, we can actually have a real discussion now. If anybody has any questions, the cameras, and let's have an actual
Wait,
discussion.
1 second. Let me just stop.